Burglary in South Carolina. Burglary second degree is defined as the entry into a dwelling or a building without consent and with the intent to commit a crime therein. In this state, it can be listed as either a violent or non-violent offense. Hi, my name is Dale Savage and I'm a criminal defense attorney here in Charleston, South Carolina. And for the state to show burglary in the second degree for a non-violent offense, they have to prove the following: that you entered a dwelling without consent and with the intent to commit a crime therein. It's a felony offense and you can face up to 10 years in prison. The second part of the statute that controls the violent offense portion of the burglary second degree statute states that you have to have entered a building without consent and with the intent to commit a crime therein. However, under this subsection, you also have to possess or commit what they call aggravating factors. And those aggravating factors have to occur while entering, remaining, or in immediate flight from the crime. And they can be one or more of the following: that you had or possessed a deadly weapon or an explosive, or that you injured a person or that your co-defendant injured a person during the commission of the crime, that you used or threatened to use a dangerous instrument during the commission of the crime, or that you displayed a knife or what appeared to be a knife or firearm, or that you have 2 prior convictions for burglary or housebreaking, or that the entering or remaining occurred at nighttime. This is classified as a violent offense and you can face up to 15 years in prison. Basically, the burglary second statute controls 2 types of structures, either a dwelling or buildings. And depending on which structure you're accused of, it'll either be a violent or a non-violent offense. So what does it mean to be a dwelling? A dwelling is basically any structure where a person sleeps on a regular basis. A building is any structure where someone doesn't sleep on a regular basis, but covers such things like offices, warehouses that aren't abandoned, vehicles, airplanes, or watercraft. So let's talk about non-violent and violent offenses. Under this statute, the non-violent offense covers burglaries of dwellings, but without any of the aggravating factors, and it doesn't occur at nighttime. If it did occur at nighttime, then that would be elevated to a burglary first charge, which is for another video. Now, when we're talking about violent offenses, that's when it encompasses a building, not a dwelling, and it has one or more of the listed aggravating factors that's required under the statute. And our courts have been pretty liberal in how they cover some of those aggravating factors. For example, when it comes to committing a burglary with the possession of a firearm, you don't actually have to have possessed a firearm as you entered that premises. If you did so without a firearm, and then during the commission of that burglary, you found and stole a firearm, that meets the aggravating factor that elevates it to a violent offense. So how do you go about defending these types of charges? Good lawyers know that it's important to start at the structure itself, and you need to determine whether that structure was abandoned or not. If that structure isn't being lived in and it is abandoned, then that doesn't meet the definition, at least the statutory definition, for burglary. It may be another offense, maybe a misdemeanor, but it certainly doesn't meet the level for burglary second, where you could face up to 10 or 15 years in prison. It's also important to determine what evidence the state has that links you to the crime. Oftentimes it can be singular evidence such as DNA only, or one witness's identification of you, or you could be in possession of stolen property from that burglary, but there's no other evidence linking you or putting you inside that structure at the time of the crime. Each of these legal issues need to be investigated by your defense attorney, and if those facts apply in your case, there can be a defense to the charge. So, If you've been charged with burglary second degree, whether it's violent or non-violent, and would like to talk about your charges, please give me a call at 843-530-7813. I hope this video was helpful, and thanks for watching.